This is Making the Case. I'm Laverne McGee, sitting in for Yodit. Attorneys in Brunswick, Georgia are getting closer to completing the first round of jury selection in the trial of the men accused of killing Ahmaud Arbery. As of today, 42 prospective jurors have been picked, but they still need 22 more before the process of selecting the final jury panel can begin. And today, attorneys on both sides received several warnings from the judge. BMC's Drake Clark is in Brunswick tonight.
Today marks the 8th day of jury selection here at the Glenn County Courthouse in Brunswick, Georgia. And the process is moving much slower than anticipated. In fact, one of the defense attorneys told the judge that he's concerned potential jurors will revolt because they're frustrated and getting tired of sitting and waiting to be called into the courtroom for questioning. Meanwhile, the judge, Timothy Walmsley, said he understands their frustration and he's trying to get through the process as quickly as he can. But he says the court must be very deliberate about the jury selection process because he wants to make sure the right jurors are chosen so a just verdict can be reached. From day one, the judge and attorneys knew the jury selection process would be challenging because so many prospective jurors either know the defendants or victim in this case, or they've read about what happened and watched the video showing Ahmaud Arbery being shot and killed with a 12-gauge shotgun. Remember, the court is obligated to seat a fair and impartial jury. Gregory and Travis McMichael, who are father and son, are charged with murdering Ahmaud Arbery. They both claim the shooting was in self-defense, and William Bryan recorded the shooting with his cell phone. And prosecutors say he was a participant in the killing, and that's why he's also charged with murder. Frank Hogue is representing Gregory McMichael. We spoke to Hogue recently about the slow pace of the jury selection process and the long hours inside the courtroom.
Yeah, we've been going till sometimes as late as 8:30 at night. Those are long days. That's 12 hours in court, and doing that day after day is pretty taxing.
64 qualified prospective jurors have to be chosen before the next round of jury selection can begin. Once the court reaches the number 64, they will have to cut it down to 16 through another round of questioning and vetting of potential jurors. The ultimate goal is to seat 12 jurors and 4 alternates. Initially, the judge had set aside 2 weeks for jury selection, but at the rate the court is moving right now, the selection process will easily go into a 3rd week. In Brunswick, Georgia, I'm Drake Clark for Making the Case.
In addition to warning attorneys about the pace of questioning, Judge Walmsley also cautioned attorneys about their tone during questioning. He said that at times it's come close to being aggressive. Well, joining me now to discuss today's developments is criminal defense attorney and private investigator Karen Felecia Nance, and also with us tonight is civil rights attorney and former prosecutor Maria O. Banjo. Ladies, thank you so much for being with us. I want to start with these warnings from the judge. We've heard him urge attorneys to pick up the pace before. Well, now he's talking about their tone. So last night, one of our guests said it sounds like it's getting hot in that courtroom. So I want you both to react to the judge getting involved now. Maria, you go first.
Yes, thank you for having me on tonight. You know, it's critical that attorneys, when they're in court, are extremely professional and as approachable as possible. Jury selection is one of the most invasive processes in the justice system, and I think it's really important that attorneys are mindful of how they speak to jurors. In the way, again, it's really important that they make sure they're very careful in how they're speaking.
Karen, what are your thoughts?
I agree with Maria. I think that the last thing that you want is for the potential jurors to feel that they're on trial. And so the demeanor, the decorum of the courtroom is extremely important. And they have to be very careful, the defense attorneys, as well as the prosecution, not to have a certain tone with who they believe is a good witness, i.e., maybe someone of the white race versus speaking derogatorily to someone of the black race. So I think that is extremely important because not only will the potential jurors pick up on that, but obviously the judge has, and maybe that's the reason for the warning.
Yeah, absolutely. I've actually been through that process. I didn't make it all the way through, but it is so intimidating, it really can be scary. In fact, ladies, some other moments stood out today also. Let's talk about the questioning of Juror 178. We know that she is a white woman, and at 18 years old, attorneys believe that she is the youngest prospective juror they've heard from so far. Now, she said she does not want to serve on this jury. In fact, she said, quote, "I just feel like I'm young and don't want to judge anyone's life," end quote. So that ended up triggering a lengthy discussion once the woman left the room. So the defense said, quote, "This juror is not going to be able to sit in judgment. No criticism. She's just too young." She was asked a number of fairly easy questions and was unable to express an opinion or memory. End of that quote. Then the prosecution rebutted, saying, quote, "Being young has absolutely nothing to do with decision-making ability. She is nervous, but that has nothing to do with her ability to listen to evidence and follow the law of the court." My question to both of you is, should age be a factor? Maria, I'll ask you first.
Yes, I mean, age is something you take into consideration when you're questioning jurors. But, age alone is insufficient, is discriminatory, and is not permissible under the law. What defense attorneys should have asked them, the juror, was whether or not they had the ability to be a fair and impartial juror, and they're able to make an assessment or a judgment based on the evidence that's going to be presented during the course of the trial. And because they failed to ask that question, they don't have enough grounds for them to have a justification to strike that person for cause.
Okay, what do you think? Do you agree?
I definitely agree. And the minimum requirement to sit on a jury in that county is the age of 18. So she meets that minimum requirement. And as Maria said, there hasn't been any evidence presented by either side that she isn't fit to sit as a juror. So I wholeheartedly agree that there hasn't been enough established at this point to excuse her for cause.
I mean, really, though, 18, it really depends on the person, right? I mean, I have a daughter, and I remember her at 18. She was considered very mature. She had some friends who were absolutely not. So is this something where they really have to take into account the person and not look at the number? Karen?
Yes, absolutely. They should follow up with questions regarding employment, their experience supervising as a manager, maybe at a grocery store, without making assumptions based on someone's life experiences. It's important that lawyers ask these follow-up questions, trying to dig deep and be able to get to the root of what they're trying to assess, whether or not a particular potential juror has sufficient life experiences to understand the nuance of evidence that's going to come out during the course of a high profile murder case. And I think, it's understandable for defense attorneys to be concerned about her age. But again, the failure to ask those crucial follow-up questions is going to hurt them.
But what about her saying that she didn't want to? I mean, if somebody doesn't want to, I mean, shouldn't it be game over at that point? Karen?
I think that the defense, as well as the prosecution, have their stab at it, which is to say that not only if they can't exclude her for cause, they can use their peremptory challenges. The defense, each of the defendants has 8 peremptory challenges, meaning that they can strike a juror without giving a reason, and the prosecution has 12 peremptory challenges. And so if they're not able through their questioning of her to establish that she shouldn't sit as a juror for cause, they still have that opportunity when they use their peremptory challenges. So I think that that's something that they do have, both sides have, and they can use that if they really feel that she shouldn't be sitting as a juror in this case.
Maria, I know people
Yes,
who will use every excuse in the book to get out of jury duty. Let's face it, from doctor's notes to, I've got a wooden leg, whatever you can come up with. So certainly we can sympathize here, especially at that age. Maria, your thoughts?
Yeah, absolutely. In all my years, in all the jury trials, I've never had someone say, "Oh, I want to serve in the jury." And the few people actually that I have seen it, it's a red flag. It's a safe assumption that when a person comes in for jury service, it's not something that people are excited about. One, you're being pulled away from your family, your routine, and in many cases, you're going to be losing wages because you're not going to be able to work. For those of the folks who are hourly earners. And so, again, it's not uncommon for folks to say, I don't want to be here because they're human, and that's okay. The crucial question is whether or not their desire to not be there will have an impact on their ability to accurately, effectively analyze the evidence that's going to come out.
All right, Karen and Maria, I need you both to stay with us. There's so much more to discuss. When we come back, we'll talk about the huge impact social media is having on this case and how things could change once we finally reach that magic number of 64 prospective jurors. We'll be right back. This is Making the Case. Glad you're back with us because we're breaking down the headlines from day 8 of jury selection in the case of the men accused of killing Ahmaud Arbery. Gregory McMichael, Travis McMichael, and William Bryan are all charged with murder. Back with me now to discuss today's developments is criminal defense attorney Karen Nance and civil rights attorney Maria Banjo. Ladies, thanks for staying with us. So many factors at play when it comes to this high-profile case. One of them is who is in the courtroom aside from the judge, attorneys, and prospective jurors. Ahmaud Arbery's father, he's often in the courtroom. And today, we also know that several members of the Transformative Justice Coalition were there as well, and that group has been rallying outside for Arbery's family. So I want you to talk about the significance of the presence in that courtroom. Karen, I'm going to start with you first.
Well, the defense attorneys asked, I believe it was yesterday or the day before, that the protesters outside be excluded because they were saying that it's prejudicial to the potential jurors, and the court overruled that objection, indicating that these people had a First Amendment right. People have a First Amendment right to protest. And so the fact that they're outside as well as inside the court indicates that the court is supportive in the sense that they're exercising their right. They're not advocating violence or causing any type of disruption, which is the reason why the court has allowed it. And so I think that it shows from the point of view of us as the public looking at this information and making sure that there is justice in this case. That's the hope, that's the expectation, and that the jurors are fair and impartial in this case. So I believe that the ruling by the court so far has been just and very supportive of the First Amendment right of those individuals that are protesting outside and those inside the court as well.
Maria, how about you?
Yeah, I absolutely agree. Courtrooms are open to the public, and, there's only certain circumstances under which when it's appropriate to close it out to certain people. I think it's important, especially for the prosecutors in this case, because this is not a very, in a lot of ways, not a very popular case when it comes to the folks who live down there in Brunswick. I mean, those of us who are in other parts of Georgia and the nation see the horrificness of this particular evidence in their particular case. But at the end of the day, this particular prosecutor has a big hill to climb. And honestly, having the support of the community and folks, is only going to help them.
Yeah, I know it's rough on that community. It's a small town. We've been talking about that. But now they're on the map, obviously for the wrong reasons, because another major factor in this case is social media. Everybody knows about this. One of the defense attorneys said that he's never been involved in a case with so much media attention. Social media came up quite a bit in court today. Juror 199 is a black woman. The defense honed in on many of the statements she's posted on Facebook that indicated she would side with the prosecution, but then they also focused on how she uses her account, noting that she's changed her profile name on Facebook several times over the course of the year. She said it had nothing to do with the case. It's just something that she does. Full disclosure, listen, I've done that before because I was hiding from my ex. Not because I was trying to get out of, a trial or jury or anything like that. I mean, it's common. To me, it's common to change your name. Some people do it if you use it all the time. I don't know. Karen, I'm going to start with you. Are details that small really important? She changed her name a couple times on Facebook, and they're talking about this.
I think that the defense is grabbing at straws. And if there's any reason that they can eliminate this woman, this Black woman from the jury, they're going to make that argument. And so it is a they're making it a big thing. And I just think that hopefully the court is not going to listen or allow this argument to go forward. I totally agree with you. We change our names on social media, and it's just something that's not frowned upon. It's something that's common. So I agree. I think that because she's a Black woman, that's my opinion, that the defense is using whatever they can to strike her for cause so they don't have to use a peremptory challenge.
Yeah, Marie, what do you think?
I completely agree with her. It's a really small detail. However, when you're trying to pick a jury, you are looking at all the small details, whether it's what book the juror brings into the courtroom, the juror's face as the charges are being read for the very first time, react to it. You're trying to get to know a juror in a very short period of time. And so these small things like someone's Facebook account, social media activity are going to be things that are going to be analyzed by the attorneys. In this particular case, changing a Facebook name does not rise to the level of anything significant.
All right, Maria and Karen, I love having you with us. I want to talk about another trial. It's starting next week, so stick around. The murder trial of Kyle Rittenhouse, that teen accused of killing 2 men and wounding another during a protest in Kenosha, Wisconsin last year. Well, the presiding judge made a questionable ruling among other ground rules for the trial, and we really need you to weigh in after this short break. So please stay with us. We'll be right back. This is Making the Case. And remember, we're your go-to for extensive trial coverage. We're committed to following the latest in this trial every night right here on Making the Case and BNC.
Hi, Jimmy J.J. Walker here. If you're on Medicare, listen to this. It's the Medicare annual enrollment period, and there's a deadline to update your coverage and benefits for all of next year. I didn't want to miss out, so I called the 1-800 number to see what Part C benefits I could get. An actual person answered and looked up my zip code, and boom! I was offered extra benefits like dental care with extractions, fillings, dentures, transportation, and so much more. All at no additional cost. And get this, based on my zip code, I can get $100 a month. That's $1,200 a year added to my Social Security check. I was like, dynamite! Call, check your zip code.
I called and he looked up my zip code and said I could eliminate co-pays and get expanded dental care, prescriptions, transportation, and meals covered at no extra cost.
I couldn't believe my zip code has a benefit that adds money to my Social Security check. They helped me so much.